everybody. Thank you so much for coming. So my name is Angela Carlson-Whitley. I'm a local attorney. I focus my practice on the area pretty much entirely of guardianship with a little bit of trust administration thrown in. I represent family guardians, professional guardians, hospitals, facilities. I do court investigation work in guardianship. So pretty much any area of guardianship, I do all of those things. I was also on the committee. There was a very small committee of attorneys who worked for about a year to prepare and draft all of the state forms that are used in guardianships. So I have a lot of background in the new statute, which we're going to talk about today. So the first thing to talk about is what exactly is a guardian or a conservator. A guardian is somebody who's appointed by the court, and they're given authority to make personal or financial decisions, or both, for someone else who can't make decisions for themselves. And during that process, the individual who's under guardianship is going to lose some very important constitutional rights if a guardianship is established. And then those rights are exercised through the guardian rather than by the individual on their own. The guardian is what we call a fiduciary, which means that they're held to a higher standard and they have to act only on behalf of the person who is under the guardianship. And when I say guardianship, I'm going to use that interchangeably with conservatorship. Under the new statute, they changed the terminology. Guardianship has to do with the care of the person, so it's all about medical and personal decisions, and then conservatorship is about money and contract rights, property, those kinds of things. But I'm just going to say guardianship because it's much easier and not as unwieldy as constantly saying guardianship and or conservatorship. So just assume I'm talking about both. So how many of you have been told that when your child turns 18, you're going to have to get a guardianship? Okay. And show of hands, who told you that? Was it a teacher? Okay. What about a doctor? A friend? Therapist? Okay, close. Maybe a friend who also has a disabled child. Sometimes it is that was my next thing I was going to say, the case manager. So if your child is already receiving services through the Department of Social and Health Services, Developmental Disabilities Administration, so DDA, so maybe your case manager said to you, you're going to need a guardianship. Well, maybe you will, and maybe you won't. In 2021, January, the new guardianship statute took effect. It's called the Uniform Guardianship Act, or UGA for short, so you're going to hear me say UGA a lot. The Uniform Guardianship Act took some parts of our old statute and incorporated them, but really it is pretty much they sort of threw out the kitchen sink and gave us a whole new statute that we all have been learning about for the last year. And under that statute, the standard, the basis for establishing a guardianship changed a little bit. And so now the focus is on, can the individual make and communicate decisions either with or without technological assistance? And if they can't, and there are no less restrictive alternatives, then the court can impose a guardianship. We have always had a mandate to use less restrictive alternatives. That has always been true, but it's even more true under this new statute. And we focus very much on not establishing a guardianship if we can avoid it in any way. We consider guardianship to be a last resort, again, because you are taking away somebody's constitutional rights, and we don't want to do that if we don't have to. The goal is to provide the individual with the level of support that they need without unnecessarily taking away those rights. So what exactly is a less restrictive alternative? There are a lot of less restrictive alternatives that can be explored when you're trying to find some way to avoid a guardianship. And again, the goal is to provide the individual with that level of support they need, but not unnecessarily take away their constitutional rights. Some examples of less restrictive alternatives include durable powers of attorney for healthcare or finances, or both, something we call the informed consent statute, supported decision making, representative payee-ship, able accounts, special needs trusts, and sometimes even joint bank accounts. And sometimes we'll use a combination of those things, or maybe one less restrictive alternative, or a couple of them plus a limited guardianship or a conservatorship, in order to provide that safety net for the person. The key thing to remember in all of these is that every child is different, every family and their needs are different, and there is no one-size-fits-all when it comes to guardianship. And you might see individuals who seem to have the same diagnosis and even the same functional level. That doesn't mean that they're going to have the same result when it comes to less restrictive alternatives in a guardianship. You might have one that does need a guardianship and one that doesn't. So every situation is very, very fact-specific. So less restrictive alternatives. Informed consent statute. This is under the Revised Code of Washington, or RCW 7.70.065. Most people aren't aware of this statute, but basically it creates a hierarchy that allows someone to make medical decisions for someone else who is unable to make their own medical decisions. And so doctors can rely on that. And if there's not a power of attorney and there's not a guardianship, the next person in the hierarchy is parents. So if you are the parent of an adult disabled child, you have the ability under state law to make medical decisions for your child, regardless. You don't need a guardianship for that. Where it becomes a potential problem situation is if there are divorced parents who don't agree, because then who's making the decision? The doctor's kind of back in the same boat. The second one that we look at that is probably one of the most frequently used is powers of attorney for healthcare or finances. And if your child has capacity, they can execute a power of attorney naming you or someone else, whoever they want, as their agent to act on their behalf and make decisions for them. Oh, we have a question already.
Capacity?
What's capacity? I just hadn't quite gotten there yet. So capacity means the individual, the child, has to understand what it is that they are signing, and by signing that document, what they are authorizing you to do on their behalf. If they don't understand that and can't communicate their understanding, then they do not have capacity to sign that document, okay? So you would not be looking at powers of attorney if that's your situation, particularly if your child is nonverbal and has no other means to effectively communicate. They do not have capacity to do a power of attorney, and that will not be an option for you. Another thing to remember about powers of attorney is that with that document, your child is sharing authority with you. They are not giving up any of their own authority. They still get to make their own decisions. You don't get to override those decisions, okay? So it's not the same as a guardianship in the sense that the person is not losing their own constitutional rights to act on their own behalf. They can always do that. They're just giving you permission to help you if they need it. Supported decision making is something new under that UGA that we're talking about today, and it allows your child to pick one or more supporters to help them make decisions. And that's basically by talking through the decision with them. What is this decision that they need to make? What are the risks and benefits, the consequences, other options or alternatives? So your job is essentially to help explain those things and talk it through with your child, but they ultimately make their own decision. You can help them communicate that decision. You can help them get information that will help them make that decision, but it's not a piece of paper. Even though it's a written agreement, you don't get to take it places and act and do things on their behalf. They are still driving the bus when it comes to supported decision making. Most of you are probably already doing that. If you have a child who has a functional level that they can have some say in decision making, you're probably doing this already on a daily basis. You just don't have the piece of paper to back it up. And now that it's statutory, you can put it to writing, and that can be an agreement that you can use to get information. Representative payeship is a program through the Social Security Administration that allows somebody to manage the Social Security benefits for someone else who cannot manage their own benefits. If you are named as the Social Security representative payee for your child, then the account that is set up will be their money, but you will be the person named as the signer on the account and the only person who will have access to those funds and manage those funds, unless and until you hand your child some cash. But up until then, you are the one who is making sure that those funds are being spent appropriately for their care. For DDA benefits, this is probably one of the biggest reasons that we end up establishing a guardianship these days is DDA and Medicaid. And that's because under Medicaid and DDA rules, your child has to be able to name somebody to be their authorized representative to handle those benefits for them. And if they can't do that, and there's no power of attorney and there's no guardianship, then you're gonna have a problem. Somebody needs to be able to have authority to manage those benefits on your child's behalf if they cannot. So if your child can't name someone and they can't do a power of attorney, then you're looking at a guardianship in order to deal with Medicaid and DDA benefits. Other protective arrangement. This is another new animal under the statute. It allows you to essentially get a court order that will let you perform some particular task that will help you avoid a guardianship. It's really used for sort of limited situations where you have just, one thing that needs to be done and then there's no more need after that point. So an example might be grandma and grandpa think, oh, this is a great idea, I'm going to name my grandchild or all three of my grandchildren on my life insurance policy and it's going to be split between them. And they don't think about the fact that one of those three grandchildren is disabled and that if they inherit money, they're going to get kicked off their public benefits. They just think they're doing a great thing, right? So if you were to go through the process of getting another protective arrangement, you could end up with a court order that authorizes you to collect those benefits and put them into an ABLE account or a special needs trust in order to preserve your child's benefits. And then you won't need a guardianship just to collect those funds. You have another means to do that. The bad thing or the unfortunate thing about an other protective arrangement is that you still have to go through the entire guardianship process to establish, just to get that court order, and incapacity still has to be proven and established. You just don't end up with a guardianship at the end of it, you end up with a court order that lets you do something, and then you don't have further court involvement after that. ABLE accounts. So ABLE accounts were authorized by federal law. They allow somebody with a disability to set aside funds, save those monies tax-free, to pay for disability-related expenses, things that they maybe otherwise wouldn't be able to pay for because they have that $2,000 resource limit if they're receiving SSI and Medicaid. Come on in. Okay, so we're talking about ABLE accounts, and you missed the beginning part. But basically, they allow somebody to save money for disability-related expenses and spend those later without affecting the individual's public benefits. They're modeled on 529 plans, so there are IRS tax penalties and ramifications if you don't spend those funds properly. But having said that, the category of things you can spend on is really quite broad, and it's just about anything and everything. So it's a great way to be able to set aside money for education, vacations, therapies, pretty much anything that your child will need more than $2,000 for. Sometimes it's dental expenses, and you just can't save up enough money to be able to pay for those things. So an ABLE account will let you do that. I highly recommend the National Resource Center website for information about ABLE accounts. Each state has their own ABLE plan, but you do not have to participate in your state's plan. Some other states will allow non-residents to participate, and that particular website has a 3-state comparison tool, so you can look at the differences between states. They all have their own custodians. It might be Vanguard, it might be BNY Mellon. They all have their different fees and options for investments and using it as a checking account. So take a look at that if you're planning on opening an ABLE account. Special needs trusts can be very complicated. I could talk for an hour alone on just special needs trusts, so I'm going to try to make this really brief. Basically, the individual can set them up, or someone else can set up a special needs trust for a disabled individual. If the trust is set up by the individual with their own money, there's a Medicaid payback. If it's set up by someone else with the other person's money, the third party's money, there is no Medicaid payback. So the difference on whether or not there's a Medicaid payback is what is the source of funds that are being used to establish that special needs trust. And they don't mix. You'll either have one or the other. You can have both if you want, but you don't mix those funds together in the same trust, okay? If you are setting up a special needs trust during your child's lifetime and you're funding it with their money, you could pay a lot of money and have an attorney do that for you. Or if your client's or your child is a DDA client, they can participate in the Washington Endowment Trust Fund, which is managed by the Arc of Washington as trustee. There's a modest $600 fee to set it up. They manage it, which means they know what's appropriate to spend those funds on and what's not, so they're not going to accidentally mess things up and make the whole trust an available resource that, you know, they're going to come after and try to take that money from you. So I highly recommend them. They're really easy to work with, and that's one way to set aside funds. And they offer both that self-funded trust, so it could be a trust with your child's money, or it can be a trust that you deposit your own money in. So you have options with them. Joint bank accounts is another option that can sometimes work, and maybe in combination with representative payeeship if your child is high functioning enough that they're going to actually work for wages rather than volunteering. So maybe they don't make very much and it's not worth establishing a guardianship or conservatorship for. You just need to handle a couple $100 a month of wages. You can open a joint bank account with your name on it and your child's name on it, and you can manage it for their benefit. There are some pitfalls with joint bank accounts. I'm not going to go into those today, but just know that there are some pitfalls. School issues. This is another one. Parents get concerned because sometimes the school says to them, your child's 18 now, you can't participate in IEPs anymore unless your child signs a document saying that they'll let you participate. But that's not quite the case. You always have the right to access records for your child, even between 18 and 21, as long as they're continuing it in school. That is federal law. And if your child is unable to provide informed consent and participate in IEPs, there's a process that will allow you to be named as their representative, their educational representative. So you can talk to your school about what that looks like and get yourself put on there as the authorized educational representative without necessarily having to get a guardianship just for that purpose. So those are sort of the main less restrictive alternatives, and again, we can use those in any combination with or without a guardianship or a conservatorship. And WashingtonLawHelp.org is another great resource, a website that has information about some of those things on there, and so I highly recommend that you take a look at that. They also have forms available online for certain things, powers of attorney, supported decision-making agreements, and some other documents. So now you're probably wondering, okay, well, how exactly am I supposed to protect my child? But it's not enough to say, my child is really vulnerable, they're going to be exploited if we don't have a guardianship. The court, in most instances, is not going to establish a guardianship based on what might happen in the future. If you have evidence that things have happened in the past, your child has been vulnerable to influence, they have been exploited, then a guardianship might be appropriate in those circumstances. But otherwise, you can file a guardianship at any time. So there's no reason not to try less restrictive alternatives first, and if they don't work, you can always go back to the court and say, look, we tried this, it did not work, we need something more than what this document was able to help us do. Another reason to avoid a guardianship is simply because it's really, really intrusive. There's all kinds of personal information about your child that ends up in a public court document that anybody can go look at. Some documents are sealed in the court record that has really very personal medical type information, but in general, there's just a lot of personal information that ends up in the court file, and anybody can see that. Another reason is if you hire an attorney like me or someone else, you can expect to spend quite a bit of money dealing with getting a guardianship established and then doing the ongoing reporting that the court requires for guardianship cases. Because once you establish a guardianship, it's not like a minor guardianship where you go to court once and you go through this process and you have a court order at the end of it that says you're the guardian, you get to make decisions, and you go on your merry way and you do that. Adult guardianship doesn't work that way. The court is always going to be supervising that guardianship and making sure that your child's needs are being met. So you're going to go back in the first 90 days and then you're going to go back at the 1-year anniversary. After that, you can stretch it out to 3 years, but you are going to be reporting to the court every 3 years for as long as that guardianship lasts. And if you have an attorney, you're going to be paying attorney's fees for that, time. So it can become quite expensive, and that varies dramatically depending on the attorney that you hire and how experienced they are in doing guardianship. I do always recommend that if you're considering guardianship or even exploring less restrictive alternatives, that you spend a few $100s and go meet with an attorney at least once for an hour-long consultation and talk through all of these things with them. Go through what the issues are that you're concerned about, talk about less restrictive alternatives, and get an appropriate recommendation. And if you do that, please go to somebody who practices guardianship. Do not go to a general practitioner or somebody who dabbles in guardianship. This is a constitutional area of law. There are dates and deadlines and things that have to be met and service requirements, and if they're not done properly, you can get all the way to the end of the process and have your case dismissed. And I can't tell you how many times I've had people come to me and say, I hired this other person and we got all the way to the end and I spent $3,000 and I don't have a guardianship. I have to start all over now. So you do not want that to happen to you. And again, maybe you can avoid a guardianship altogether. So go see somebody. You wouldn't go to a heart doctor for foot surgery or vice versa. So don't go to a general practitioner. Find somebody who is experienced in guardianship law. How am I doing on time? I have a few more minutes. Okay. So let's say you met with somebody. You talked to them. You've determined that you either need a full guardianship, maybe just a limited guardianship, and you want to actually go through that process, whether you're going to use that attorney or do it on your own. You can find all of the necessary court forms on the Washington Court's website. If you just do a Google search for Washington Court forms, they'll pop up, and every statewide pattern form is on that website. It does not come with instructions, unfortunately. But basically, you're going to file a petition with the court. You're going to file what's called a notice of guardianship petition, which is a notice to your child of all of the rights that they can potentially lose through a guardianship and what their rights are through this process. And then you're going to get a court visitor appointed. A court visitor is just a fancy name for an investigator. They're going to meet with your child. They will meet with you. They will probably talk to the DDA case manager, maybe a teacher, somebody other than just you, because what they're looking at is not only whether or not your child meets the statutory basis, do they need a guardian, are there less restrictive alternatives that could be appropriate, but also, are you the appropriate person to be the guardian? And so they're not going to just want to talk to family members who, of course, are going to speak about you in glowing terms. They're going to want to talk to disinterested third parties like the case manager or a teacher. Once the court visitor is appointed, your child has to be served within 5 days of filing that petition, 5 business days. It doesn't matter that they maybe won't understand the paperwork. They're entitled to notice that this is happening, and they get service and copies of all of those pleadings. The court visitor also gets served, and then they get 45 days to do their investigation and get a medical report from your child's doctor. And it's not just a, gee, I went to the doctor and he says I'm great. It is a specific statutory form that requires very specific information from the doctor about your child's functional level and their diagnoses. The court visitor will file their report, ideally within that 45-day timeline. And then you will have 15 days to review that report before the case will come to hearing. And that's because we have a statutory deadline of 60 days to get a guardianship established. If it's not going to be done in 60 days, we ask the court for more time. At the end of the 60 days, the court, the commissioner, in Thurston County we have a commissioner, will review all of the documentation, review the report that the court visitor filed, and make a ruling on whether or not a guardianship is appropriate in your child's case. Okay? So that's kind of the overall process. Once you're appointed, you file an acceptance that you're willing to be appointed. You'll get letters of guardianship. So you'll have a court order that says you're appointed as the guardian, and then you'll have a one-page piece of paper. In Thurston County, we get paper with a pretty local seal on the bottom. That is your letters of guardianship or conservatorship. It's your official authority to act as the guardian for your child. So very important. You will have to file a disclosure of bankruptcy. Very rarely you might have to obtain a bond, probably not for anybody in this room. If your child doesn't have lots of money, you're not going to have to file a bond. Or if it's a guardianship of person only, you're not going to have to file a bond. When you're making decisions for your child, we exercise something called substituted judgment. That means you have to take off your parent hat and you step into your child's shoes and make the decision they would make if they're able to do so, if they can understand the decision that needs to be made, or if they're not making a decision that's going to put them at significant risk of harm. Because we all have the right to make poor decisions and to learn from our mistakes, as long as it's not going to significantly harm them by doing that, okay? So that is the decision-making standard. And then after you've gone through that beginning process, within the first 2 weeks of establishing a guardianship, your child gets notified that this guardianship has been established. They get a copy of the court order. You're required to file a notice with the court saying that you did that. And then depending on what kind of guardianship was established, you'll be doing either a guardian's or conservator's plan and possibly an inventory. You'll have to have a hearing on those things and get court approval for them. And at any time, if you move, your child moves, your child experiences some significant change, a hospitalization, or they do inherit that life insurance policy, you need to notify the court with a written notice that something has changed. Or if you're not sure, you can always file a motion with the court just to ask for instructions, and the court will be willing to help you. So that is the basic overall down and dirty quick version of guardianship. And the most important thing to know is if you do get guardianship established, do not miss your reporting deadlines, because your letters of guardianship do expire, and they expire coinciding with the date that you have to file your next report. So if you forget about it, you're running late, be sure you go back to court and ask for new letters and ask for more time to get that report filed. Otherwise, you don't have authority to act, and if an emergency comes up, you can be in a whole lot of trouble. So, okay, technically, we are literally out of time. I am happy to hang around and answer questions, but I don't know if the next presentation, we have 15 more minutes before they start. We're good. Okay, so if anybody has questions, I can answer questions. Yes, ma'am.
So between a guardianship and a power of attorney, does one override authority over any?
You cannot, I can't say you cannot. You can have a combination. You can have a guardianship for handling money and a power of attorney for healthcare only.
Okay.
Guardianship would supersede typically a power of attorney. Usually we don't do a guardianship if a power of attorney is working. If it's working, then we just use the power of attorney. If we have problems, then we go to court and we get the power of attorney revoked because it's not working, and we establish a guardianship instead.
And so you also mentioned that as a parent, you would have the right to say so, the next person to, like, with the health and all those type of permission. Do you think that with me being a parent, the power of attorney is necessary to have in place as well?
I'm not sure I understood the question. Say it again.
I think I came in the middle of it. I think you said if the child as an adult, he's not able to make his own decision, and so the parent will be the one that would consent and make the decision on their behalf. Am I correct? The next person in line? Or
You're thinking of the informed consent statute, which is for medical decisions only.
Okay.
And it is a statutory hierarchy of who can make decisions.
Gotcha. So that's just for the health.
That's just for medical decisions only. It doesn't
Gotcha.
cover anything else.
Okay.
Yes.
Okay.
Yeah.
So you mentioned like power of attorney, you can get different categories or for power of attorney, but with a power of attorney, the child has to be the one to name or...
Yes, they have to understand enough to know what they're authorizing somebody to do, and they get to decide who they want to name as the agent. That's the person who's going to act on their behalf. So they decide who that person is going to be. Now, if you, most of the time, if your child, let's say you brought your child into me, and I'm going to assess them for capacity to do powers of attorney. If they're able to tell me, I want mom and dad to continue helping me with school and at the doctor's office and with my job and managing my money, that's probably going to be enough for me. I would be willing to draft documents on that basis. But they're the ones who decide. And typically it's going to be mom and dad. they can revoke that document at any time. And so if they did, for example, have a boyfriend or girlfriend in the future, or somebody who just latches onto them and thinks, I can access this person's Social Security benefits, name me as your agent. You know, they could present a power of attorney. They get online to your child, and your child could, you know, sign a new power of attorney that revokes the prior powers of attorney. That happens, that's when you would go to court and say, I need a guardianship, this is not working. Does that make sense?
Sorry. So what about like, it's the whole medical thing with my son, because he, you know, when you go, he can't fill out 15 forms that they need. So I wanted to be able to do that for him. Also, like when he has forms sent to him by like DDA, DDR, where it says he has to sign, chances are times I want to sign for him because he's refusing to sign. Not just because by choice he doesn't want to sign a piece of paper, that's it.
Sure.
Not what it's pertaining to. So is there something I can get for all of that, or should I just concentrate on the medical point?
I mean, that would be a guardianship, really. If you're running into situations where he doesn't want to sign documents, either just because he doesn't feel like it at that moment,
yeah.
or, you know, doesn't really understand, then you're probably looking at a guardianship because you've got more than one thing going on. You've got DEA, you've got Medicaid, you've got, you know, medical. You've got enough things there that would probably make sense in that situation to do a guardianship. We haven't really explored it too much yet, but, and partly because DDA is not too keen on the idea, but there's a possibility that another protective arrangement could be used in that kind of a situation. They don't like it because eligibility reviews happen, you know, not infrequently.
Yeah.
And so they don't want a court order that sort of lasts forever. In their view, well, that's a guardianship. You know, you don't get a court order for that. The OPA is designed to just be for a one-time thing, and that's not really a one-time thing. So in those kinds of situations, if you have enough of those different little pieces that your child is either unwilling or unable or doesn't understand, then I would probably be exploring guardianship. Another big one is sedation dentistry. Sedation dentistry can be a big issue in terms of consent and dentists not wanting to perform that without a guardianship or a power of attorney, something on paper that authorizes somebody to make that decision for your child's behalf. So
as far as, okay, so if I just forget the DDR and like it whatever happens, it happens, we'll eventually get them to sign. As far as the medical, like going to a new place, filling out all that paperwork, is that where I can get and
you can do that. I mean, you can make medical decisions under the informed consent statute, and if you just need to access information, if your child understood it, you can do a supported decision-making agreement. What is your child's level of understanding? Would he understand those
it's like
concepts?
high functioning.
I mean, if he would understand those concepts, then you can do a power of attorney, or he could do a power of attorney or supported decision.
Yeah, as long as I go over it with him quite a few times, you know, obviously he'll eventually get it and stuff like that. Yeah, I just want him to be safe. You know, if they go, hey, you know, obviously let's do this, and I say no, well, you can't say anything, and that's the thing that worries me a whole bunch.
And that could potentially still happen with a power of attorney, and then you deal with that when it happens. And if you need to do a guardianship at that point, then you do a guardianship at that point. But maybe it doesn't happen, and maybe you're able to do everything you need to do with a power of attorney and not have to go there.
Okay.
Sorry, I have one more. I apologize. Oh, sorry.
Sorry.
Go ahead, go.
Well, so when people first are watching, we have like a lot of self-advocates around the state. What we run into a lot with our membership is that parents get guardianship, so it's a thing to do, and then they pass away, because that's what happens to us all. You become disabled yourself and pass away. And then it ends up just transferring. It's not like it disappears, but it goes into somebody else's hands that doesn't have the person, doesn't know the person, or like there's just some weird thing where somebody else ends up controlling, and they don't have the money to undo it or the understanding of how to become your own guardian thing, because you know, after 40-some years, they develop some skills they didn't have 40 years ago. And
So guardianship is never static. You can always go back in. The individual themselves can go back in and ask for that guardianship to be changed, to be reduced in scope. right now, because of the changes in the statute, our courts are, especially in Thurston County, are routinely looking at, well, how old is this guardianship? When was it established? You know, does the person still need this level of support? And they are pretty much revamping every case, and most of them are getting reduced in scope. And if it's not really clear, the court appoints a court visitor to reinvestigate and to meet with everybody and to make a recommendation as to what, are there less restrictive alternatives at this point that were maybe not available back then? You know, what has changed? What can we get rid of? So
If your current guardian doesn't want to give up guardianship,
there is a statutory form and it's on the Washington Court's website to file a complaint against a guardian. All they have to do is send that into the court. They can drop it off. They can mail it in, and then the court has to take action. So the court reviews the complaint and will either schedule a hearing or appoint a court visitor or ask the guardian to come in and explain why this should still be, whatever the issue is, you know, should still be going on. So somehow or other, it will get dealt with. So all they have to do, and you can help them with that as advocates, is fill out that complaint form, has a cover sheet, send it into the court. Yeah. Okay, we have a few more minutes.
Sorry, I just wanna, so I just wanna know, like, cause in my situation, right, like, I have one son, he just turned 16. What is your advice as far as, like, guardianship? Like, do I go straight to a lawyer? Like, my husband is to active duty, do I start the process? I hear different things like, wait till he's 18 or don't wait, because the time frame to get this could be years.
No, it's
So
not
I'm
yours.
just like, where do I start in case my husband's leaving next year, right? My boy is 16, I want to be proactive and being able to give him that smooth transition and help that he needs, whatever that looks like. But are you telling me, like, in order to start the process of a guardianship, I have to go to a lawyer that practices guardianship?
No, you are never, okay, so the question is, does she have to go see a lawyer to start a guardianship? And if your child is only 16, should you be starting it now? Do you wait till they're closer to 18? You are never obligated to go see an attorney. You can always represent yourselves. It's just that guardianship can be really complicated and you might mess things up and just create more work and stress and possibly expense for yourself if it has to be redone later. You never want to start when your child's 16 because they're still a minor, and if you establish a minor guardianship, it terminates when they turn 18.
Exactly.
So you need a guardianship based on disability, and you don't want to do that until close to 18 or after 18. So I would not start more than a couple months before they turn 18. It takes roughly 60 days if it's done correctly. And it shouldn't take too much longer than that, especially for a simple situation when you're just doing an adult disabled child. The other thing to think about is if you're military and you're moving periodically and you establish a guardianship, it can be kind of a hassle. So I have many clients who are military, and sometimes they keep the guardianship here and they move around, and usually that works fine because they're typically getting services on a federal installation and they'll recognize the Washington guardianship, and then when they retire somewhere, then we transfer it to wherever they're going to be. You do not want to be transferring it every time you move duty stations. It's expensive, it's a pain, it takes 4 different hearings to transfer because you have to ask for permission on one end and then on the other end and get another order on this end terminating this one and then a final appointment on this end. So very complicated. You can, if you're having problems with somebody recognizing it in another state, it can be registered as what we call a foreign judgment because all of the states have to give full faith and credit to orders from other state courts. And so it's a way to basically get your court orders filed in the state that you're in at the time if people are not listening to the fact that you have a guardianship in that state. But if you're military and you're going to be moving around and your child maybe can utilize less restrictive alternatives, that's going to be a whole lot easier than dealing with a guardianship, unless one is really necessary.
And any one of these we just call, like, the state and start, or like whether the least restrictive alternatives, all of this is just like a process that we go online?
It depends because all of them are different, and so that's why I recommend meeting with an attorney to talk through those things and figure out what is going to be appropriate for your situation, or whether any of them are going to be appropriate for your situation.
Thank you so much.
Oh, one more.
So just to be clear here, in order to establish your guardianship, you have to show that there's some harm, actual harm, there's some bad outcome to justify that level of giving up of their rights.
Or that there's something that they need that you can't get any other way.
Okay.
Yeah.
We don't have to let them walk through traffic first, though.
No,
Okay.
that you do not. Absolutely not. Okay, any more questions? Okay, well, thank you all for coming. I appreciate it, and hopefully that was helpful.